The infographic I've posted on the website is really important. It's the most thorough and complete visual explanation as to how the complex New Jersey foreclosure system works. If you go to almost any other attorney's website and they have any infographic, it starts here when you're in foreclosure, it ends here when you lose your house. And I guess it's supposed to explain to you the different steps that the bank has to take, but it doesn't tell you what I'm gonna do for you to fight the bank. And you can't do a simple, straightforward line because not everybody's case is the same. Where the banks violate the rules differs each time. And where I can trick the banks into violate the rules differs depending on what mistakes the banks make and what silly traps they fall into that I set for them. And I lay out the different steps in the process where the banks are the most vulnerable so that you can see in general how long the process is going to take.
But here we go. The default is the date that the bank says you stop making your payments. What this line here represents is what happens if you don't answer the complaint. So let me give you a free pro tip. The most important thing you need to know with regard to foreclosure defense. Answer the complaint. Answer the complaint. If you don't answer the complaint, you're on the short road. Nobody wants to be on the short road, except the bank. The bank wants you to be on the short road. This is the road that happens when the bank gets total control over the foreclosure process. If you think you want that, you're in an unusual situation because I don't know anybody who wants the bank to control this process. I want you to be in control of the process. I want to be in control of the process. I want to interfere with the bank's desire to be in control of the process as much as possible. Going back to here, this is the entry of default. This is when you stop paying. The bank sends you a letter called the notice of intent. Right here, you see this reference? Notice of intent. This is a letter that's generally sent not by the bank itself, but by the bank's lawyers. It's very important that you reach out to an expert in some fashion, an expert in this business, when you get the notice of intent. Because a notice of intent provides for you a number of benefits and opportunities. For example, you can send a Fair Debt Collection Practices Act demand letter, making them explain exactly what is owed, and that creates leverage for you if they do it wrong, if they fail to send the letter. But it has to be the right letter, has to be sent to the right address. And that's this right here. If you send that letter, you buy yourselves 30 days. If you don't send that letter, you're not going to get the 30 days. At some point, the complaint is going to be served. That is a tough day. I know it is. I've spoken to people face-to-face and face-to-face COVID style thousands of times since 2007, and I've yet to find a person who said, oh, that was really fun. I really enjoyed being served with a foreclosure complaint. In fact, I want to do that again. No, it sucks. It's scary. You're hoping the day doesn't come. You know it's going to come, but maybe they lost your file, which does sometimes happen. Day arrives, rubber hits the road, now you have to deal with it. And dealing with it is the most important thing you can do. If you do nothing else, if you take no advice from me, if you stop watching this video right now, fine. Here's the advice right at the beginning. Answer the complaint. If you don't answer the complaint, the bank is in control. You're down this road. This is the short road. You don't want to be in the short road. The bank wants you to be on the short road. The bank wants to be in control. Your job, my job, is to prevent the bank from being in control as much as possible. And the number one most important thing to do is answer the complaint. I have blog posts on my website that walk you through the process of answering the complaint. You can do it on your own. You can hire somebody else. You can hire me. That's your best option, to be completely candid. But you can do this on your own. And I explain how on my website, and you can find that under the press and the blog posts, and you'll find it alongside a ton of other information. So the complaint gets served. You have 35 days to answer the complaint. Don't miss those 35 days. Don't miss 35 days. Don't. I don't care if you took out a loan with Bank of America and Bank of America is filing a foreclosure complaint and you know you didn't pay and you know you owe the money. I don't care. I still want you to answer the complaint because the bank still has to prove its case. Even though you might think that the bank has every every potential of being able to prove its case, make them prove the case. If you don't answer the complaint, they're going to go to a final judgment within 14 days, sometime, well, 30 days plus 14 days, almost slightly less than 2 months. If you do answer the complaint, there's a case management conference where you go to court, or I go to court, answer questions from the judge, explain what the case is. Then you have 90 days just from the summary judgment, which gets skipped on this side. This is where the bank says, Judge, there's no issue here, and we're entitled to a judgment on the note. Okay. Maybe they'll get it. Maybe they won't. Maybe there's an opportunity to negotiate another 90 days before they get to the final judgment stage, which they would get in 2 months on this side. Any way you slice it, you're looking at months and months more time by answering the complaint, even if you can't poke any holes in the bank's case, even if the bank didn't do anything wrong, and that's not usual. But let's stay on this side here, okay? This side here is what happens when an answer is filed. You go to the case management conference, you look at the bank's proofs, and the bank is right. There's nothing wrong. There's no payments that you made for 6 months that the bank has failed to account for in its payments, in its history. They got everything right. They prove to you that everything's straight. You work out a delay. They get to their final judgment warning. Then you sit down and you say, okay, I think right now is the time that I want to negotiate a settlement. So we're talking about maybe 6 months. That's 6 months of not making a mortgage payment. That's 6 months of buying your own forbearance. That's 6 months of saving money every single month. When you get to here, when you get to the final judgment warning, which is a notice that the bank sends, you need to understand something incredibly important about federal law. And this is something you're not going to hear from too many attorneys in the state of New Jersey. You're just not. You go to another lawyer and they're going to say, you know what you need to do? You need to modify the loan right now. Really? Maybe sometimes, but not always. Most of the time, it's better to start modification here. Let's take a for instance. Let's say that you are like, most other homeowners in New Jersey, and you've got some credit card debt. You've got some leftover car loan. You've got a medical issue you could deal with. This is where we deal with it. Outside of the foreclosure process, you and me, we talk, we figure it out. We clear up your other debts, whether it's by discussing about a bankruptcy filing, whether it's negotiating with your creditors, whether it's using the 6 or 8 or even 9 months sometimes of delay of no mortgage payments for you to clear up all the revolving debt that's been just dragging you down for years and years, and get rid of it. Get rid of it. So that when you get to here, you'll have the debt. Guess what happened if you listen to the other people who told you to modify the loan right now? The worst case scenario is that the bank says yes. And I know that's probably blowing your mind, but it's really true for a significant percentage of people. I would say the vast majority of people, one of the worst things you can do is modify the loan rather than make the bank prove your case. Think of it. Let's say you got $30,000 in revolving debt and medical debt and other expenses. And you have a mortgage payment of $3,000 a month, including taxes. And I can get you 6 months of time not making the mortgage payment. What do you think we could do with the $30,000 worth of debt? You think you'd still have it at the end of the 6 months? Maybe, but not nearly as much, and you probably won't have any. So that when you do sit down here and start talking about a modification, and I'm going to tell you why you want to modify right now as opposed to above in a second. When you do sit down here and start talking about the modification, you're looking at a clean balance sheet. You're looking at, I've got income here and I've got no expenses. None. Oh, food, I got to pay, insurance, but none of this revolving debt that is destroying the middle class in this country. It's gone. It's taken care of. So when you sit down and negotiate with the bank, and the bank says yes to a modification, it's probably the same one you would have gotten here, except this time, you don't have any of that debt. Your life is better because of a foreclosure complaint, because of a foreclosure defense, because of how you responded to a foreclosure complaint. Let me get back to a point I made before. Why it's important to start your modification process around here. The reason is because under the Real Estate Settlement Procedures Act, which is the federal law and the federal regulations that govern the mortgage servicing industry, when you submit a loss mitigation application, which is a modification application, the bank cannot proceed to final judgment or sale until they resolve your modification application. So at this point, right here, you're at an inflection point. You can stop everything. You can take your 60 to 90 day negotiated delay. Remember, this is where the bank wins their underlying case because they're right. And you're still looking at about 6 months, 5, 6, 7 months from the date of filing the complaint. But you get to the final judgment warning and you boom, and you insert a loss mitigation application, a modification application. Well, guess what? Everything stops. Stops completely until your modification is resolved. Let's say in the beginning you would have given you had everything you needed to get the modification and you passed on it wisely and you filed it here. So you get to a modification that is basically the same thing you would have gotten 7 months earlier, but now you don't have all the debt. Let's take another for instance. Let's say you don't qualify for the modification, which is a close call and you hope to, but you really think you're not going to. At the end of the 7 months, you're either going to have cleared up enough debt so that you do qualify for the modification and you haven't blown your chance to force the bank to stop because they only need to stop once on one modification application. And if you submit it here and don't quite qualify, the bank does not have to stop when they review you here when you actually do qualify. But let's peel the onion back even once more. Let's go back to here and let's assume that you would not have qualified under the modification here, and you don't qualify under the modification here. That's tough. It's not a good situation. But here, if this is the first time you submit the modification, the bank still has to go through the process. They have to review your documents. They have to review everything. They have to follow up to make sure you've submitted everything. They have to make a decision. They have to alert you to the decision. They have to give you an opportunity to appeal. They have to review your appeal. And then if you ask the right questions and send the right letters, which I always do, they have to give you all the documents they relied on in making their decision. And I'll get to that in a second. But put aside what you do in the face of a denied modification. Consider what I just said. That can be up to 3 months, 3 additional months before they can go forward beyond the final judgment. Here, 2 months to final judgment. Here, 6, 7 months to application for final judgment. And then you put your modification application in and you buy yourself probably another 2 or 3 months. You're looking at a long time of savings. You're looking at a long time of clearing up debt. You're looking at a long time to make the preparations that need to be made if you just can't keep the house. And that's not usual. It happens. It's not usual. Keep in mind all of these things because all this time, you haven't been making your mortgage payment. Yes, your mortgage has been getting bigger. Your loan has been getting bigger. There's no denying that. But if you're going to modify the loan, you're going to smear that out for 30 years, and it's going to be an insignificant increase in your monthly payment. So it's kind of like it doesn't even exist. For the purposes of determining whether or not it makes sense to modify on a month-to-month basis. In other words, from your income to your expenses given the modification. That's a long time to clear things up. That's a long time to get your life back in the saddle. That's a long time to get another job or start another career or open a business because you don't have to make a mortgage payment. And it wouldn't let you anyway, unless you modified. There is, simply put, no benefit in the vast majority of the time to filing a modification application here. Is it always true? Of course it's not always true. But the number of times when it's not been true has been so tiny as to be next to zero. And the times that it's not the best approach is when you're one of the few people in the world who really can't afford to have a foreclosure complaint filed because of the industry in which you're in which case you need to modify the loan here. But if you're not one of those, and they're actually very, very few, then you don't need to worry about it. Let's go down to here, though. Let's say that you don't get the modification. They deny the appeal. They didn't make any mistakes in the appeal, which is something that we review as part of the modification process. If they do make mistakes, well, then we're going to move over to this side of the menu, but we're not even there yet. Let's assume that the bank didn't make any mistakes. They're right to deny you under their own guidelines. They get the final judgment. They denied the settlement, the modification. You're probably a year out at this point. And then you end up with final judgment filed. Remember, you're 2 months on a final judgment being filed here. Here, you're a year. And then when they file the final judgment motion, you get to review it and oppose it. If there's a mistake, you oppose that. And they have to deal with it. In the court decision, 30 to 60 days I have here, it's probably longer in the days of COVID. Now you're talking about 14, 15 months minimum. Then they issue the final judgment, writ of execution, which sounds worse than it is, although it's not good. They have to schedule the sale. Then you get 2 one-month adjournments. But the scheduling of the sale, that's sometimes taken an incredibly long period of time. And it doesn't help them. Here's a fact about RESPA. Do you remember what I said to you up here, where I said when you get the final judgment warning, you apply for your modification, because on that first modification, they have to stop everything before they file their foreclosure judgment or their foreclosure sale. Remember I said that? It's 100% true, but there's an exception to it that applies to you, not to the bank exactly. Well, it's to your benefit. And that is, if at any point in this process, after you do your first modification, the bank transfers servicing or sells the loan, you still have your first modification, because the first modification application is first modification application per servicer, per default, per owner. So if the servicing changes, you didn't get it over here, they may have different guidelines. You get to go in at any point during this process, sometimes right after the final judgment order is issued, and make them go through the process again, adding another 2, 3, 4 months, and hopefully getting the modification at that point. There is no benefit to not answering the complaint. The number of times I've heard people come tell me, oh, I was in foreclosure, I reached out to a third-party company, not lawyers, out of California or Florida, did a modification for me. I swear to you, I just want to bang my head against the wall. I mean, you just threw $10,000 away. You just poured it down the drain. Worse than that, you harmed yourself by giving these fraudsters your money. Don't. Let's go to the right. Let's go to this side of the screen. Kind of skipped over this, because if you thought this was complicated, this is insane. I love insane, because I like driving banks insane. So here we go. Answers filed, and I know the bank screwed up this case. And I know the bank screwed up this case because you told me. You know, we get on the phone and you say to me, look, I made 3 payments to Bank of America. They assigned the mortgage and transferred service into Wells Fargo. My payments disappeared. Wells Fargo put me into default. I've been screaming at them and bashing my face against the wall over and over and over again to tell them I'm not in default. Then they stopped taking my payments and they filed a foreclosure complaint. Well, guess what? We're over here. We are over here, 100%. And if you ran into someone who told you to do a modification of the loan, go get your money back, because that is nonsense. You have a fight, and I want to be that guy who fights for you. So this is what this is, the RESPA investigation and discovery. You get discovery over here, even on this line. Prove, bank, show me that I'm actually in default. But if the bank is right, they're going to be able to do it. Here, the discovery is a little bit different. Bank, show me all the payments that you show against the account, because I'm in the same time I'm gathering from you the proof of payments you've made, and I know they're not going to match up. Or you've told me you modified the loan, paid a number of months, and then the bank breached the modification. Okay, I want your account history, bank, and I want all of the account notes that anybody made on the file, and I want recordings on every single entry anybody made on that recording history. There's a huge fight. banks' heads explode. We don't want to give that to them. Well, too bad. You know, if you have a reason to get it, I can usually get it. And if we find a RESPA violation, which if they have screwed up a modification, if they have failed to account for payments, if they've done anything untoward regarding your servicing, we're going to find a RESPA violation. And that's where we get to here. Federal lawsuit against the loan owner, federal lawsuit against the opposing attorney sometimes. That comes in when we tell the attorney, look, here are all the problems. You know, payment was made, payment was not acknowledged, payment was made, payment was not acknowledged. You guys are 3 months off and then you refuse to take payments. You can't proceed on this case because you're trying to collect money and foreclose on something you're not entitled to do, and you're the debt collector. So you're going to get sued in federal court by me under the Fair Debt Collection Practices Act for trying to cheat my client, or more accurately stated, for helping your client, the owner of the debt, to try to cheat my client. And the fact that you're going to be personally liable, here's my email laying out the facts. Don't come crying to me later when you have to pay my client damages, attorney's fees, credit repair, all this kind of stuff, because you are on the hook and your client. That's where this comes in, okay? That's not just the Fair Debt Collection Practices Act against the attorneys who are doing the collection. That's here. That's not just the RESPA suit for violation of the Real Estate Settlement Procedures Act. The way that works is we find a violation, which you tell us about, we identify. In here, we make the bank tell us all the facts. Then we send them a notice of error and say, look, you're wrong. You got to fix this. They don't fix it. We get to sue them. Oh, and by the way, your foreclosure is going to go bye-bye. Credit damages? How many people have said to me, you know, they didn't account for my payments. I made the payments on time. And then they put me in foreclosure. They destroyed my credit. I had a business go sideways. You know, I couldn't buy this other house. I couldn't get the financing for my daughter's college. That is a very, very serious problem. And I guarantee you, that when you went to another lawyer, they told you to modify up here. And they didn't understand how to deal with the credit injury. They didn't understand how to deal with the RESPA violation. They didn't know what an FDCPA violation was. It is a difficult, complicated business, and you have to be able to sue banks in federal court. And if you don't sue banks in federal court, I'm speaking to other attorneys, you shouldn't be handling these cases. Period.